daily cost list, item number 1.
This matter relates to the appointment of the agent of the district council. A lot. That is, may take though there is no dispute with the terms and condition of the NID. If you allow, Lordship allow me, just invite Lordship attention to terms and condition of the NID and go to the impugned order. Lordship permits me. Now, Lordship, the NID is available in page number 57, my lord. This was published on 18 October 2021. May I take, my lord, may I take point number 3. 3 places were notified. At the bottom, my lord, the details of check station, location, earnest conditions, and such. Now, we are concerned with the Mukuntur. Mukuntur is specified at the bottom. And last date of submission and time is 2nd 11/2021, 2 p.m. That was the last date of submission. And thereafter, the next page, my lord, page number 58. Tenure of the appointment would be 3 years. Point number 5. Period of appointment is for 3 years. It is mentioned here. Now, may I take to point number 7, condition number 7, bid system.
No, what is this NIT concerned with?
For appointment of an agent by the district council to check the illegal trading by the non-tribal in the district council area.
No, in essence, it means to man a check gate.
My lord, to check, because many non-tribals were engaging in business within the territory of the council area without any license. In order to check that one, and there is leakage of revenue also. So there is an act, Non-Tribal Regulation Act. Under that act, they have the power to appoint, to regulate this. So to check and regulate this one, district council has decided to appoint an agent. Therefore, they offer NIT, inviting willing candidates to come forward to appoint them as an agent of the council for a period of 3 years.
So what exactly will be the function?
The functions to check the, my lord, to check the...
You have to go from place to place?
No, my lord, there would be a check station. They will publish. Successful bidder will establish a check gates near the highways, and there they will check whenever a vehicle coming across.
So you're checking vehicles?
You're checking vehicles, my lord. Okay. Flying vehicles, especially by the non-tribals, they will check whether there is a valid license or not. If the business engaged by them is in accordance with the 6th schedule or not, tribal area. Their duty is to check that one.
But how do you distinguish that checking part with the function of the regular police?
But
the regular police also will do the checking for any suspicious vehicle or any vehicle for that matter.
But police duty is confined to the law and order. Here, the police is not empowered to check whether tribal, non-tribal is doing business or not. But here, district council is strictly confined to the non-tribal for engaging in trade within the territory without any permission. And the 6th schedule allow them. to regulate, to check this one. So they frame the act.
That I can understand.
Well,
you see, that I can understand. Whenever a non-tribal set up a business concern, then the district council or any authority for that matter, empowered to do that, will go and check and see if you have the license,
right,
whatever.
Right.
But how does it connect with checking of vehicles?
My lord, now the non-tribals are engaging and non-tribal vehicles are there, the drivers are there, the businessmen are there. Now they ply in the national highway, in the highway. Now they establish a checkings. So they ask them to check whether they have a valid license or not. If there is a valid license, they let them go. If there is no valid license, then they find out that one, and the law will take its own course. And for that checking purposes, the agent is allowed to collect 200 rupees per vehicle of the non-tribal, not the tribal, not the tribal. Yes. So that is the business given to the agents. Agents to be performed.
Yes.
Lordship, when we go through the terms and conditions, Lordship will be more revealing, my lord. I take to condition number 7, page number 258. My lord, the bid system, it says, tenders complete in all aspects are to be submitted in 2 bids, technical bids and financial bids separately, subscribing technical bid for in the envelope and financial bids. So 2 bids are there, may not take a long time, my lord. Then technical bids, the down there, my lord, these are the following documents are required to be furnished by the tenderer along with the technical bids from the person such and such. So these are the required documents it is mentioned there. Now financial bid also same thing. Now may I come to point number condition number 11, my lord, page number 59. Examination of eligibility criteria documents. Now the tender documents will be examined by the tender committee to determine whether the bidder meets the eligibility criteria and whether the technical bid is complete in all respects. Any bid found to be non-response for any reason or not meeting the eligibility criteria will be summarily rejected. Now they have a proper tender committee, they examine everything. Now conditional number 12, the next page, page number 6. Deciding the successful bid tenderer, the bidder quoting highest price H1 shall be considered the successful tenderer, and on refusal of the HI bidder, the bidder with the second highest bidder H2 will be treated as, and so on. So these are the order of the declaration, my lord. Now may I come to 15. It says that communication of acceptance. Successful tenderer will be informed of the acceptance of his tender, and a letter of appointment will be issued to the successful tenderer within 10 days, working days. Necessary instructions regarding the amount of necessary security deposit and time provided for payment of the premium for the first quarter will be communicated. Execution of the agreement. After acknowledgement of the letter of appointment by the agent, he or she shall make the payment of the premium for the first quarter as offered by him or her in the receipt sale of the district council. Subsequently, a deed of the agreement shall be signed by both the parties within 10 working days. So the agreement will be executed. Now here the matter yet to reach that stage. Now the terms and conditions, my lord, terms and conditions specified in the appointment of the agent. My lord, this is more clear, my lord. Agent shall be set up check station at the location mentioned in the letter of appointment at his own cost. Lordship, this is very clear, page number 61.
Yes.
The agent shall be allowed to set up office to check and identify all the illegal trading by commercial vehicles of non-tribal traders conducting business within the jurisdiction of the council only. However, the agent shall not be allowed to erect gates or barriers across the roads or highways for fulfillment of his duties. Appointment shall be for a period of 3 years. Agent shall, my lord. These are the terms and conditions, my lord. My lord. Now may I come to the next page, page number 62, condition number 10. Point 10 is there. The operating expense fee allowed to be collected from commercial vehicles of non-tribal traders conducting business illegally within the Council's territory after proper verification of documents and related papers shall be rupees 200 only per case detected. This will be done under the strict supervision of the officer deputed by the Council to carry out the purpose of Rule 30 of the such Act. Now, the 11th, the Council shall have the power to rescind the contract shall be agent fail if the agent fail to comply with any or all of the above terms and conditions after giving 3 months notice to the agent along with enough opportunity of being heard. Number 12 is important, my lord. The Council shall not appoint any other agents, introduce or set up any other work, service or enter into contract with any other person or party to operate the same or similar kind of business during the pendency of the agreement signed or enter with the agent. Now, these are the terms and conditions. Now, there was a technical bids open. 11 candidates faced the bidding process. Now, only 3 of them sailed through the technical bids. 3 were declared as successful. Now, they are supposed to face the financial bids. Now, therefore, the District Council, page number 65, they have communicated to the writ petitioner to participate in the financial bids. May I read, my lord? 17 December 21. Opening of financial bids, it says, my lord.
Yes.
I am directed to inform you that your technical bid for Makuntur Check Station received against the redenter notice dated such is found to be responsive and your name has been shortlisted as technically qualified tenderer. As such, you or your authorized representative are requested to be present on the 28th December 21 conference room for opening up financial bids. So we were invited. Similar was done to others also. Now, what happened thereafter? Lordship, kindly see page number 66. 66. Now we have, since there was a delay, after I was declared as a highest bidder, there was a delay of offering appointment and execution of agreement. Therefore, I have served this notice. May I take Lordship attention to point number 3 to save Lordship time. Upon the technical bids being opened, the tender committee found 3 eligible bidders, amongst whom I was also declared successful. Thereafter, the tender committee intimated me and the remaining 2 successful technical bidders to remain present on 20 such for opening of the financial bids. On such, I was present for the opening of the financial bid. The tender committee opened the financial bids, and upon opening, I was found and declared to be the highest bidder, H1, and accordingly, the tender committee informed me that my name is being recommended for appointment as agent. In view of the above, I request your kind office to issue the communication of acceptance for appointment as agent for Makuntur to me and execute the agreement with me. So this was my request since there was a delay. Thereafter, my lord, nothing was done. There was page number 67. I have issued a legal notice to the respondent council to expedite the process. My lord, I may not take the content of the.
This was page 66 was dated.
Dated, my lord.
December.
December, my lord. 20 December. And my lord, the legal notice we have served. We serve on 21. My lord.
21.
Page number 67 onward. That is legal notice. Page number 67. That is date 21 December 2021. And we made a reminder again.
I mean, the very next day you issued this notice.
My lord, there wasn't because they issued the very next day. They issued the very next day the notice for expediting. In fact, that is to expedite the process only. Not that we repetition accuse them that there is a delay, inordinate delay, but urging them to expedite is a contract matter.
You could have waited for a response.
Of course, my lord, that is also there. At page number 71, my lord. 71, January, the next year, my lord, 17 January 2022, page number 71, I issued another representation reminding them to expedite.
Yes.
Well, so at this stage, my lord, technical bits completed. The tender committee comprises of the expert, the officers of the councils. They verified all the documents, eligibility of all the candidates, including the suitability of the land, everything, and they declare me successful in the technical bits. Second, financial bits, I am the highest bidder. Therefore, all the formalities are completed. Now, the only two steps they need to be taken is they have to issue letter of appointment, and within 10 days, execute the agreement. Then we will start the running of the check station. Now, since two steps were delayed, therefore the communications were there, reminder was there. Nothing happened. Thereafter, my lord, surprisingly, page number 74. This is one of the impugned. My lord, this is the executive committee resolution taken on, my lord, 8 February 2022. Page number 74. May I take, my lord? It is important.
Yes.
My lord, may I read, my lord? Views and opinions of legal advisor regarding checkpoint at Muguntur. The chief executive members placed the agenda in the executive committee. He informed all the members about the legal opinion on the legal notice regarding checkpoint at Muguntur, an inspection report of the department concerned. He then sought the views and opinions of the members. The assistant licensing officer briefed the executive committee that the office of the JGTC had issued retender notice dated such 18 October 2021 with respect to checkpoint at Muguntur and Amlarim such. Thereafter, the tender committee, who was tasked to oversee the bidding process, had white letter such 20 such, had recommended to the executive committee the name of Redalin Law as the successful bidder. She also briefed, and the executive committee has directed Sri such trading inspector, taxation department, and checkpoint to inspect the land proposed by Srimati such to set up the checkpoint at Muguntur and to submit report forthwith to the executive committee. The inspector submitted his report with finding as follows: that the land where Ritalin proposed to set up the check station is situated at the right side of the national highway from Chawai to Shillong. Right side. If the checkpoint is set up in the said land, the staff have to cross over the trading license of the vehicle. Number 3, if the checkpoint is proposed to be set up, does not have sufficient space to stop vehicle to check the trading license, and if the land is used as checkpoint, and if the vehicles are stopped, it would result in traffic jam, thereby causing inconvenience to the vehicle in the highway. The member pointed out that the annual premium quoted by Srimati Ritalin for single checkpoint at the rate of rupees and such is an illusion, as it is far beyond the annual premium quoted by the ex-agent dated such. The executive committee member in charge taxation pointed out about the instruction received from the District Council Affairs Department, Government of Meghalaya, hereinafter referred to District Council Affairs, that gate should not be in the way, but away from the highway having pylons. He also mentioned about the revenue leakage faced by this office due to no collection of fines from trucks without trading license, and mentioned that after scrutiny of the land, it is found that the land proposed by Redalin is not feasible and does not have sufficient space for checkpoint. As such, it is not expedient to appoint Redalin Law as the agent for the opening of the checkpoint at Muguntur. In consideration of all points mentioned above, the executive committee, after thorough discussion and deliberation, unanimously decided to stand by its early decision, that is to appoint Mr. Rudolph G. Kendia, his second bidder, as a lessee agent of the Muguntur check station. Consequently, the representation is possible. Now, the my notes this we have challenged. Now, apart from the expert committee of tender committee, now they revisited, they deputed the inspector, departmental level, and they collected another report, and the land suggested by me is not suitable. Though the technical process, that was all examined, suitable. Now suddenly, it was not suitable. My land was not suitable. But the land offered by Mr. Gindia in the right side of the same highway is suitable. Therefore, they selected the second person.
Yours is on the right side.
Yes, my one is the when we go from here, from
Right side
Shillong
of the
highway, it is right side. And Mr. Gindia one is the left side.
left side.
Yes. Therefore, then the committee said it is suitable. Now, when the executive committee sit together and they depute one staff and they collected the report and they said no, the land offered by retail land is not suitable, another one is more suitable. So, because of that, they decided to appoint Mr. Gindia. We challenged that one in the first writ petition, and the order was passed, madam, the next page, 75 onward. Madam. His appointment, Mr. Gindia's appointment was nullified by this honorable court, dated by 26/9/2022 by the learned single bench. And may I take the relevant portion, relevant para 13 to 14, may I take the same judgment. Madam, page number 86 onwards.
Para?
Madam, may I take para 12 to 14 of the judgment. It will start from page number 85.
85.
85, madam. It's a short judgment. Right.
Yes.
May I read, madam? The above noted judgment has become the benchmark on which such matters are considered by courts and have been followed by various other judicial pronouncements, including the authority cited by both the parties herein. Accordingly, therefore, by applying the same principle in the considered view of this court, the non-settlement of contract with the petitioner cannot be said to be affected by bias or malified, inasmuch as the reason ascribed in the decision such appear to be based on factual consideration. However, the only element of concern is the fact that the respondent number 3, after finalization of the bids, had embarked upon the exercise to ascertain the viability of the offer of the petitioner. No doubt, well, the findings reflected the complication that would arise in the operation of the check station by the petitioner. But however, the fact that the decision to not settle the contract with the petitioner, when essentially the petitioner had met the criteria as prescribed by the NIT, deserves to be relooked at by the respondent number 3. Though the principles of equity and natural justice do not operate in the field of commercial transaction, and whenever a decision has been taken in public interest, courts do not interfere in the instant case. However, to strike a balance, limited interference is called for. Accordingly, the impugned letter and such issued by the respondent number appointing number 7, Mr. Gindia, as the counsel agent for the check station number contour is set aside and quashed. It is further provided that as the NIT did not prescribe specific criteria and requirement to meet the norms of setting up toll stations, the respondent number 3 is directed to have a relook at the decision, especially the process thereof, before any decision of the allotment is taken. It has been brought to the notice of the court that there have been subsequent development whereby the state government have issued certain orders which have a bearing on the operation of such check station. All these considerations shall also be taken into account when the respondent review the decision. As at the initial stage itself, this court had, by order dated such suspended the settlement of the check station and directed that if any checking need to be done, the same to be done so departmentally. The same shall continue till the matter is finally decided without such. So this was the order passed by the court. Appointment of Mr. Gindia, second bidder was set aside. And the learned single bench that you relook before you take the final decision, you take into account all this process, the government instructions and others. Now, district council exercised that relooking everything done, and they say that yes, it is in consonance with. Therefore, they issue a letter, page number 88, the next page. This was my 26th October.
Respondent number 3, the earlier direction.
But
Who was respondent number 3?
Respondent number 3 is
he was directed to relook.
This is a district council exit committee.
District council who? Which authority? District council which authority? We is what?
Madam, may I just point out?
The matter they went from tender committee. It was taken up by executive committee. No, have you should have challenged this order if that be the thing.
Madam, I'll just. But who is response number 3? Yes, district number 3 is the executive committee.
So it means the matter went out of the hand of the tender committee. Tender committee became infructuous. It has become useless
My lord,
after this order.
my lord, according to me, though district council is directed to executive committee is directed to relook, my lord. Admittedly, but then the process was completed over, and therefore, my lord, though district council committee is directed to relook,
See,
they are supposed to confine.
Just one thing. So far as the last order is concerned, the order
Yes,
which you have read out just now,
yes,
it interfered with the decision.
yes,
Okay, send back the matter and directed that matter be relooked.
yes.
But the relooking part was to be done by the executive committee.
Executive
So
committee.
it means the tender committee became useless. It had lost its role.
My lord, its role is over.
Its role is over.
Its role is over.
Then what happens to the tender notice which says that there will be a tender committee or something like that? No.
My lord, therefore, my humble submission, if I understand properly, though the executive committee is directed to relook, my lord, they have to relook within the confines of the NIT, no doubt read with the my lord, subsequent developments. They cannot come up with a new terms and conditions, my lord, in fact. Now, the district council, therefore, executive committee relook it. And when they relook it, my lord, they are not deviating from this from the NIT. I'll just show in the same page number 80,
That's all right.
the content, my lord.
Please
You
continue.
can proceed. You can proceed.
My lord. Page number 88, my lord. May read this. This is the letter offered to me, my lord. Now they go to the High Court order also. Now, with reference to the subject and letter cited above, I am directed to inform you that the Executive Committee JGDC Jawai in its meeting held on such has relooked into the matter of Mukuntur Check Station for identifying, detecting the illegal trading by non-tribal commercial vehicles, various licenses, while authorization and such. After deliberation, the Executive Committee has decided that the allotment of the check station may be considered to the highest bidder extremely redundant if the location of the land to be used for the purpose of check station is feasible for the check station with lay-by. Because may just stop here for some time. The NIT also provided lay-by. The land I offer also it is still there. The space is there. Now they got it now. Therefore, you are requested to arrange a suitable land with lay-by that can be used for purpose of operation of check station, so as not to disturb the movement of the traffic along with national highway. Kindly note that you are to comply with the requirement of providing land and lay-by for operation of the check station within a period of 2 months from the date of issue of this letter for consideration of the Executive Committee as deemed proper. Executive Committee as deemed proper. Now, therefore, this was the letter. Now, they say that we objected to the land offered by you, but the right-hand side is suitable. So, she has, petitioner has offered. Even in my first one also, it fulfilled the condition. But if you have objection, he got the other side with the Mr. Kendia offer. And there was a listed also executed. With the land offered by Mr. Kendia also not belong to him. It belongs to somebody else, but through lease, because the NIT permits. That not necessarily the tenderer should be the owner of the land. They should at least have the list to comment. Now, because of that, the petitioner, my lord, appellant, page number 89, he has given this reply after this matter. Madam, with reference to the subject cited above, I assume the Retalen have the honor to inform you that I have arranged a suitable land with lay-by located in Mukuntur on the left-hand side of the national highway while traveling from Jawai to Shillong for the purpose of operation of check station. So this is the letter. Now she has since the land offered by her is objected by the other side, and in fact district council advisor go to other side. So other side also I can offer.
Please continue.
But it is same left hand side, left and right only. Same highway, there is no distance, left and right only. And that is because of the report of the district council that it is not suitable, other one is more suitable. Therefore, they even offer to Mr. Kendya. Now, therefore, petitioner said, okay, if you raise objection against my land, other side is there, I can provide that one also. That one. This was the letter response to the district council. Now, by the next page, page number 90, they passed this impugned order. And given to me 16 March 2023. Now, may I read my lord? I am directed to inform you that the Executive Committee, JHHDCHY, in its earliest decision dated and such, had resolved to offer appointment to you to operate the council checkpoint at Mukuntur, provided you make necessary arrangement for a suitable site to operate the checkpoint. The said decision of the Executive Committee was communicated to you by white letters and such. In a subsequent development, one of the tenderers had issued a legal notice on the ground that if the appointment is given to you for operating the checkpoint at Mukuntur by changing the site not originally offered by you at the time of submission of the bid, the same would be against the tender documents and the terms and conditions stipulated therein, and it was impressed upon the Executive Committee that any action in that regard would only lead to a fresh round of litigation. Therefore, the Executive Committee in its meeting held on such upon deliberation and discussion on the matter decided to recall its earlier decision dated such, and accordingly as consequence thereof, letter under reference above is issued to you stands cancelled. Now they are saying that the failed candidates, but has it issued legal notice. Therefore, that will result to a litigation, fresh litigation. Now, this was also found by single bench that this is absolutely on this ground you are changing your cancelling the letter is absolutely not tenable. The single bench finding is also there. Finding is also there. Now, this was the letter I challenged before this Honorable Court regarding this, and they have filed the affidavit in response to my writ petition. Now, let us, Lordship may keep in mind, who is Mr. Kendya? Mr. Kendya is no longer in the fray. Well, no longer in the fray. Therefore, it amounts to a notice or issued by any other persons. But that cannot be sole basis for district council to change its stand. That's what I learned at single bench. I'll come to that paragraph. Now, we filed this writ petition, and district council has filed the affidavit. My lord, page number 91 onward. And I will take the relevant para, my lord. May I take para 6, my lord? Para 6 and 7. That will be page 94. Page 94. Para 6 may I just read, my lord. With regard to the amendment made and statement made in para 11 of the writ petition, the opponent denies the same and states that pursuant to the order dated such passed by this Honorable Court, the Executive Committee convened a meeting on such and resolved that the petitioner may be appointed as a lessee agent provided petitioner makes necessary arrangement for a suitable site to operate the check gates. The said decision was intimated to the petitioner by letters and such stating that District Council has decided and the allotment of the check station may be considered to the highest bidder, Stream Data Land, if the location of the land to be used for the purpose of the check station is feasible for the check station with a lay-by so as not to obstruct, disturb movement of traffic along with the national highway. The petitioner was accordingly asked to comply with the requirement of providing lay-by within a period of 2 months for consideration of the Executive Committee's concerns. Now may I come to my lord, para 7 sub, my lord, para C, my lord, para C and D. The reason they supplied, my lord. Then I give my submission. It says, In the meantime, the respondent district council received a legal notice dated sunset issued by the second Peter, Mr. Kentia, stating that in the event the executive committee accepts the proposal of the petitioner, which was never part of the original tender document, the same would vitiate the entire tender process and lead to fresh ground of litigation. On receipt of the state legal notice, the respondent district council sought for legal opinion. Upon thorough deliberation of the matter, the executive committee by resolution such resolved to recall the earlier decision dated such and to entrust the executive committee in charge this taxation to work out the manner and mode of appointment of an agent of the council who shall operate the checks gate on behalf of the council on commission basis. The petitioner was also duly informed about the recording of the earlier decision later dated such. That in the meantime, the respondent district council, while running the said check station at Mukuntur, departmentally observed that running a check gate at Mukuntur is not feasible at any further because of the increased traffic in VIP movement. And the check gate of Mukuntur is causing traffic jams every now and then, and that the state government has instructed to keep the traffic movement of the national highway unobstructed. Accordingly, the district council needs a large amount of lot of land at Clarency and started running the check gates and such departmentally. So this is the reply. Now, with regard to my lord, first the reply, they admitted that the sole basis for recalling is legal notice. Legal notice. Now, if my lord, check station open in Mukuntur leads to obstruction of free movement of the vehicles. My lord, the land offered by Mr. Kindia was the same position. But when Mr. Kindia offered, there is no traffic jams. There is no obstructions to national highways. But when I come there, same left and right, same highway, there's a traffic jams. There would be obstructions of the movement of the vehicles. Well, this is, my lord, according to me, this cannot be considered as a reasonable basis for recalling. And learned single bench correctly helped this one. They correctly helped. Now they have supplied the VIP movement others. This is not reflected in the impugned order. Therefore, they are supplementing the reasons apart from the reason available in the impugned order also. I'll cite the judgment later. Now, might just take to para 9 of the same affidavit, the last para 9, right? Page 97. With regard to the affirmation and statement made in para 17 of the writ petition, the deponent denies the same and states that while later it is and such, the petitioner was intimated only that the district council has decided that the allotment of the check station may be considered to the petitioner if the location of the land to be used for the purpose of check station is feasible for the check station with a lay-by, so as not to obstruct disturb movement of the traffic along with the national highway, and accordingly was asked to intimate if she can arrange such a land with lay-by within a period of 2 months for consideration of the executive committee. By the state letter, the petitioner was not asked to set up any infrastructure or to make any investment in state land. The letter censored in no manner can be construed as a letter of appointment, as such no legal right of the censor. So they replied that one. Now only the condition in the letter they offered to me is that the land should be feasible. According to me, both are feasible, therefore your technical committee also found that it is feasible. But only because of your objection, internal objections, I also offer you the other side, right sides. That too equally feasible.
But at this point of time, they've already set up the check station at Klitrushi.
At this point, not yet. But after we file district petitions, then they come and show that we went to Clarency, 5 kilometers away, and start running departmentally. It is not departmentally also. There, my lord, Parat, here the page 96, it is very clear, on commission basis. Now, that too also, the person who was asked to run in the Clarency, he was also one of the failed candidates, Tendera, and they appointed him. Well, the only reason, my lord, that I'm not the blue eye boy of the blue eye lady of the council. I'm not the apple of the eye. When Mr. Kende offered his land, it is suitable, there is no traffic jam. There's no obstruction of national highways. But when she comes, all the problem comes there. How can it be? They have learned a single bench, my lord. I'll come to that one. Apart from this, my lord, Lordship, kindly see the ground taken there. Page 100, my lord. The documents of District Council annexed in that. My lord. Page 100, my lord. May I just read out, my lord. Opinion on legal notice of such and such. This is the Executive Committee resolution taken on 14 March. The opinion of the legal advisor, such on the legal notice and such. May come to second para. As what could be discerned by the legal advisor, the legal notice is what issued by Mr. Such on the purported ground, and the Executive Committee intends to issue appointment order to such and such for operating the check station in respect of Mukuntur check station at another location, not originally offered by her at the time of a submission of the bid. According to the legal advisor, if the appointment is to be given to Stream Italian, it ought to be on the same terms and conditions stipulated in the tender documents at the time the tenderers submitted their respective bids, meaning thereby that such appointment would be given only at the original site offered by the tenderers during submission of their bids. He also thus opined that any appointment given to Italian cannot be made at a new location that would amount to changing the terms and conditions of the late tender, and the same could also be appear as clear indication of the deviating from the original terms and conditions of the tender only to accommodate such. The legal advisor therefore justified the issuance of legal notice and has advised the Executive Committee not to proceed with the issuance of any appointment order to the Redalin at the alternative location. In the event the process of appointment is initiated, the Executive Committee should recall the same. Executive Committee needs earlier decisions and such had resolved to offer appointment to Redalin, provided she makes necessary arrangement for a suitable site to operate the checkpoint. Pursuant thereto, later such. Upon deliberation and discussion on examination of the legal opinion of the legal advisor, the Executive Committee has therefore resolved the following. The early Executive Committee decision letter to such is hereby recalled. The Executive Committee shall communicate to the Stream Redalin regarding the recalling of the later decision, and the later is cancelled. Executive Committee hereby entrusts CEM and EM in charge taxation to work out the manner and mode of appointment of agent of the certain. So they are referring to a legal notice. Now the tender committee has found that it is suitable, my land is suitable. Even I don't have any objection that if the check station is, my lord, constructed in my first place of land. There is no such objection. Only because of the internal objection raised by District Council itself, that okay, if you have problem, other side is also available. Only that one. Now, page 101. Mr. Saventang was one of the field candidates was appointed. Page number 101. Yes. To run in the clearancy. And now, my lord, in the last occasion, pursuant to lordship observations, they have nullified this appointment. This was given to him without any tender. Therefore, this honorable board came down heavy in the last occasion. So they nullified this. Now the learned single bench say that two issues raised by learned single bench while refusing to grant the, my lord, relief in my favor. One is shifting, I did not challenge. Two, appointment of Mr. Tang, I did not challenge. So there is no question of appointment of Mr. Tang arises now, as of now, because he is nullified. My lord, I filed my rejoinder also. May just take my pleading. My lord, may take page number 109 of the writ appeal, para 7. And I'll come to, my lord, page 101. 101, my lord.
100
Recalling the decision. It's a bit lengthy rejoinder paragraph, therefore, to shorten it, my lord.
101.
Page 101.
101 is the
My lord, on the top, recalling of the decision. The wording, my lord. May I start from there? Page 101.
no, you have referred to this one.
111, my lord. 111.
You said 101 and now you say 111.
I'm sorry. 111, my lord. 111.
Yes.
Recalling of decision to appoint the petitioner as a lessee agent to operate the check station in Mukuntur on the opposite reason is totally arbitrary, unreasonable, and unjustified. As stated earlier, the petitioner having been found the highest bidder by the executive committee of such while reviewing its earlier decision as per the direction of the Honorable Court contained in judgment and such. Therefore, requesting the petitioner to arrange suitable land does not amount to deviating from or revising essential terms and conditions of NIT. Such an additional condition requiring the successful bidder, that is the petitioner, to perform do not affect the right of any other participant in the tender process. In any case, the second highest bidder having been disqualified by an order of this court do not have any locus to raise such an issue before the respondent. Therefore, recalling the order that too without affording a opportunity of hearing is illegal. So this was the short reply we have given. Now the District Council Executive Committee was asked to reconsider by the High Court. EM reconsider it, then okay, everything is in order. You give us the proper suitable land. Then I offer it. Now, when I offer, my lord, it is absolutely not feasible. District Council may take a decision, like Lordship has pointed out, that forget for the time being, the role of the tender committee is leaving aside. Now, District Council Executive Committee has taken over. And if District Council Committee found that the land offered by me now will lead to, my lord, traffic congestions, obstructions, on that basis they take a different decision, that is another. But now they are acting upon the legal notice. That's my reply. A disqualified person who serves a legal notice, and the land also doesn't belong to him anymore. And the landowner has to lease out the same land to me. And therefore, you are relying on that disqualified person, and cancelling that order is unreasonable. That was my.
No, but that issue was dealt with by the single bench.
Single bench. And single bench upheld entertained the contention of the writ appellate at that point. Now, may I come to the impugned judgment now, my lord. May I start from page number 128? A short judgment, may allow me to read it, ma'am. I'll be very clear. Start from para 7.
Yes.
Para 7. The complaint of the petitioner as to the shoddy treatment that has been meted out to her, in spite of being the highest bidder for the contract, appear to be genuine and has some basis, inasmuch as the tender has been abandoned by the respondents, divesting the petitioner of her valuable right to the contract. Judicial review in such a matter, which are commercial in nature, only take place when there is overwhelming evidence of arbitrariness, biasness, or irrationality. In the instant case, it cannot be helped but be noticed that the writ petitioner has been surely discriminated against by the actions of the respondent. In this regard, first, on the allotment being granted to her on 26th then such, the petitioner, as per the condition, had leased out the plot of land which had undeniably been found suitable in the earlier occasion for establishment of the check station. But the same was withdrawn on the basis of legal notice of Mr. Kindia. The apparent reason for the same was to avoid future litigation, which is absurd inasmuch as the said Mr. Kindia is not party to or part of the award of the contract to the petitioner, and therefore lacks any locus to caution the same. Secondly, arbitrariness is writ large, as the writ petitioner before the cancellation was not intimated nor given any opportunity to represent against the same. Thirdly, the decision to abandon the entire contract and to operate the same departmentally by appointing an agent does not appear to be rational, but rather as content by the petitioner made with a view to circumvent the entire process and to render the order of settlement useless and redundant. In the backdrop of the facts as aforementioned, however, certain other aspects have also been taken into consideration. The re-examination, the settlement with the petitioner, and the cancellation, it is noted as has been attributed only to the location of the check station, which was found unsuitable. The evaluation and the award of contract are essentially commercial functions, where the principles of fairness and natural justice have limited applicability. As such, the court therefore have no discern on the face of the particular case if the decision regarding the award of contract is made in good faith and public interest, and will refrain from exercising the power of judicial review, even if there are certain procedural irregularities, evaluation errors, or potential loss to a tenderer. This court, in the early round of litigation, WPCs and such orders and such, while setting aside the appointment of such and such as agent for the check station at the earlier location, Mukuntur, had directed that the respondents have to relook at the requirement and specific criteria to meet the norms of setting up toll stations. It now appears that they, by their impugned action, have instead chosen to abandon the entire process of award of contract to private individuals by running the check station department at a new location at Clerency, which is stated to be at a distance of 5 kilometers from Makundu. This subsequent development, no doubt, has changed the entire complexion of the case and has given rise to a new course of action, which is not covered by the pleadings made in the instant writ petition, which are confined only to seeking direction to formally appoint a petitioner as agent to operate the check station at Mukuntur, and for execution of a formal agreement as per the decision of the respondent dated such. The decision as brought in the considered view of this court, in spite of the sequence of events that reflects a flawed decision-making process in awarding and thereafter cancelling the settlement of the petitioner without hearing her, are in the present circumstances, however, no longer available for consideration. Coupled with the fact is the presence of the element of disputed facts, especially with regard to decision to relocate the check station based on the evaluation as to its suitability and the operation thereof departmentally by the respondents. What cannot be ignored, however, is the manner in which the entire exercise, which had commenced from the award of contract in initial stage to second highest bidder, which was cancelled by the order of this court, the subsequent events of settlement of contract with the petitioner and recalling of the same by the impugned order, and finally the abandonment of the entire tender process by resorting to a change of location and operation by the respondent themselves, which does not apport well for a constitutional authority as such as the council. The petitioner, by the actions of the respondent, has therefore been put to unnecessary harassment, undoubtedly also pecuniary loss. Though cause is normally awarded against petitioner or plaintiff who engage in frivolous or vexatious litigation, the present case, in the facts and circumstances of the case thereof, however, called for exemplary costs to be inflicted upon the respondent GTC for the arbitrariness shown in the entire decision-making process. Accordingly, it is directed that the KGTC, through Secretary of the Committee, shall pay a cost of 2 lakhs to the petitioner within a period of 15 days from the date of this order. My Lord, therefore, the entire action of the council is, my Lord, the learned single bench also held that it is illegal. It is illegal. Only on 2 grounds, abandonment or shifting. It is not pleaded, it is not challenged. And appointment of Mr. Tang. Now, Mr. Tang appointment is not authorized. Now, my humble submission regard to this is that if my Lord, the original order itself is illegal, my Lord, once the foundation is collapsed, pillar is taken away, structure ultimately falls down. That is the law. Lordship is very much aware. Now, if the basis of the decision taken by District Council held by learned single bench that the basis of cancelling on the with reference to the legal notice is illegal, that was taken away by learned single bench. It is illegal. He's a third part. He has no locus. He has no right to interfere with. So on that basis, how can you revoke that one, that letter? But once that is taken away, subsequent shifting to clemency, my lord, according to me, I cannot run after them. If I run after them, then they'll go to my lord, another place. There will be unless litigation. Therefore, the main, my humble submission is the foundational actions of the Respondent Council, whether it is permissible or not. Learned single bench, it is impermissible. Only because of technicalities of that, not challenging that one, I cannot grant you relief as break by you, but impose costs. With due profound respect to the finding of the learned single bench. Learned single bench became too technical, my lord, too technical regarding this. Regarding this, my lord, I don't need to challenge.
Technical in the context of a contract,
Yes,
as has been observed.
my lord.
Usually, the principle of equity
Yes.
will not apply. To that extent, perhaps.
Right. And Lordship is correctly pointed out, Lordship Justice Padajarji, that the task was given to the exit committee. Now the task given to exit committee is to keep in mind the subsequent development that come forward from the state government. And therefore their role is very limited. And they apply their mind. If they apply their mind, and therefore both the plot offered by you and Mr. Kende is illegal, not feasible at all, I abandon and achieve it, then they may take that plea that, I've taken my decision, apply my mind, I'm not giving you. There would be a change of game, changing of the terms and conditions of NIT. They may say. But District Council Executive Committee did not say that one. That we examine it, we verify the records, the lands are both left and rights, you give a land, suitable land, with a lay-by. What has a lay-by? But since internal objection is going on inside, therefore I offer, if you want to take, you can take this one also. Otherwise, the original one is also still there. But only on that ground.
So, according to you, see, your main ground for appeal is because the impugned order passed by the learned single bench was too technical, too rigid.
Yes, for refusing to grant the relief prayed for.
What is
Prayed for. Otherwise, the entire argument, contention advanced by the petitioner was entertained by the learned single bench. And the argument advanced by the other side, counsel, is in fact not accepted. Save and accept learned single bench refer to the earlier judgment that we ask you to keep in mind the requirements. The requirements. District Council apply its mind, its committee, and give me the offer of appointment. And now subsequently they receive a letter from a person who has no locus. And they review again. Therefore, learned single bench said it is incorrect. And with due respect, we subscribe. That is a correct finding of the learned single bench. But when the action of the council is illegal, then the learned single bench, with due respect, need to travel further and consider the relief. Because he is sitting in the equity jurisdiction. If this is permitted, with due respect, is there nothing less than abuse of process. The writ petitioner is not the right person, and after that also the division bench, they say they sought for time for offering for settlement. I pointed out briefly that we said for sitting together that we cannot see you, we cannot give you appointment. If you want, you offer another third person, you bring another third person. If not, you come to clemency, we will run 50-50%. This is the public largest event. Now, tender process, if this is allowed to happen, the tenderers, my lord, tenderers where tenderers will go. And it is not because of the interest of the public interest. It is not for public interest. Because they notify the Mukuntur. They know that Mukuntur serve public interest, not the clemency. If the clemency serve public interest, it could have been included there.
What do you want at this stage? What can we see? There are certain things,
Yes.
certain queries.
Right.
Now, your earlier round of litigation,
Yes.
which interfered with the order of settlement, remanded back the matter,
Yes.
with the direction to relook at the requirement
Yes.
and specific criteria to meet the norms of setting up the station.
Yes.
Now, which way do you say? Relooking at the requirement means what? As per the conditions stipulated in the tender, or the executive committee will take into consideration the situation which was prevailing at that point of time, and they will put some more requirements. What is that?
But
This is one thing.
yes.
Now, probably, see, like this order, earlier order, after this earlier was passed,
Yes.
the requirement posed by the tender, how much relevant it was? Because court said that to relook at the requirement, would it mean the requirement which was already there in the tender notice?
Yes.
The requirement clauses which were put already in the tender notice.
Right.
Was it meant that when the matter is relooked, the relooking authority will confine themselves only to the requirement which is stated in the tender,
Right.
or it is something else?
Right.
This is one point.
Right.
Now, second thing, now you have come here, see, the single judge's order, it has said the tender process which was it is abandoned. So once it is abandoned, it is gone. Okay. And these authority concerned, they were fined. 2 lakh rupees were awarded. Now say supposing if there is a fresh settlement, this will be a fresh cause of action, you file a fresh petition. Why you are here?
But
If they make any settlement in Clay-Sirsi,
yes. Yes.
that would mean that the earlier tender, as held by the, see that come to the order, page 131.
131.
Yes. Did you read paragraph 12?
My lord, referring 131.
Yes.
Para 12.
Yes. What cannot be ignored? Just from read.
Yes, madam. May I read it, madam?
Yes.
What cannot be ignored, however, is the manner in which the entire exercise, which had commenced from the award of contract in the initial stage to the second highest bidder, which was cancelled by the orders of this court, the subsequent events of settlement of the contract with the petitioner,
Now
and
just yes.
recalling, I continue, my lord,
Yes.
recalling of the same by the impugned orders, and finally the abandonment of the entire tender process by resorting to change of location and operation by the respondent themselves, which does not abode well for constitutional authority, such as the KJTC.
Just pause for a moment. It means what? It has been held that has been abandoned earlier tender. Once the location has been shifted, it's gone. The tender notice also doesn't exist now. Now, if there is fresh settlement to be made in Clay-Sirsi, then there has to be a fresh tender. You see,
My lord,
Just because
I got a
this-
lordship query.
entire exercise was taken under arbitrarily by the GHDC. The landed single judge has imposed cost 2 lakhs rupees that you will receive. But then that receiving that would not debar you from challenging that order.
My lord,
That is what you do that.
my lord, they have given me the 2 lakhs
There is
also.
no
We have
requirement of
refunded.
interfering with this order. Why should you interfere?
My lord, lordship, kindly see, this observation is on the basis of the earlier order. Earlier
See,
order, lordship has
Mr.
referred
Sandesh,
to.
With due respect, there was something in the earlier order which you also should have challenged. How could it be reconsidered by the executive committee, not by the tender committee? Moment you do it, that means you deviate from the tender notice. Now, since earlier order remained, so that became binding. Okay. Now, if any authority reconsidered the matter on the strength of the earlier order, judicial order, it will have supremacy over the tender condition. Then, relooking at the requirement, you cannot blame that part of the executive committee to go and find out by themselves that traffic jam would be caused and all. That is their finding, and they have done it as part of the single bench order, which you have not challenged.
My lord, that one, after the learned single bench given a first direction to the executive committee, and if they take a decision that we will not do here in Muguntur anymore, this will result to traffic hindrances, shifted to clearancy.
Yes.
That gives a fresh course of action. Lordship is correct. I bow down. But that is not the case here. They say we examine. Honorable High Court directed me to apply. Re-examine again, relook the entire matter again. We relook again, examine again. We found you. You're suitable. Only you provide, you give us the land with a lay-by. Lordship, just with a lay-by. With a lay-by. In my case, also lay-by is there, but since internal report is there, therefore, we say other side, we offer.
Sorry to interrupt. The description of the requirement was given in the tender itself.
My lord?
Was the description of the requirement for the land and the lay-by was.
But it is part of the tender document, list, tender document.
That's why you have.
Otherwise, they would have rejected.
Why do you have technical parts and financial parts? Technical parts is for those things only, to see the requirement.
Exactly.
After you fulfill the requirements, then only you come to financial.
Correct. Lordship is correct.
So you cannot say that this tender notice has not given this requirement. It has to be implied.
It is there.
Okay. Now see, normally, if this tender notice has not been interfered, and if it remains, that means that whatever condition is stipulated there, that will bind the authority. That it has to bind the authority. Okay. But then, after passing of the single bench order, the earlier order, not that which is impugned.
Yes.
Okay. But there is a slight change in the situation. Because that point of time it was directed to the authority concerned to relook at the requirement and specific criteria. That means, which way you interpret it?
My lord,
that means
point.
The executive committee was given the power to relook at the requirement and criteria.
Yes.
That means definitely there will be there could have been some deviation from the original condition which was stipulated in the tender.
But therefore, that first order, Lordship is correctly pointed out, first order to relook it. Now, that observation came from this Honorable Court, learned single bench, when we challenged the appointment of Mr. Kintia.
Requirements and specific criteria.
Yes, my lord.
That is the word
Specific criteria. Because that point, my lord, in the first writ petition, the government, when we challenged the appointment of Mr. Kintia, other side, the government came up with the argument that there is an instruction received from the government that the council should keep in mind the traffic flow, requirements of the free movement of the traffic and others. So because of the learned single bench put that observation that you should keep in mind, well, you reconsider it.
See,
and this accounts.
Probably you see, like the interpretation has to be what is given in the words actually used. Okay, if you see that the relook at the requirements and specific criteria to meet the norms of the setting of the stations.
Yes.
Okay. Now, if you're looking at the requirement and criteria to meet the norms, what it would mean? This is one thing.
Right.
Now, probably I do not know. My lord will definitely have this thing. It's a lordship. Probably my lord will definitely. You have seen your prayer in the writ appeal?
Yes. Earlier writ petition. In the writ appeal. Two full appeal are there. The prayer. May I come to that prayer portion?
It is not something that 2 lakh cost has been awarded to you in lieu of the contract. It is not that. Do not misinterpret it in that way.
Well.
See, come to page 19.
Yes, my prayer is page 19.
Just see alternatively. What do you say?
Alternatively, my lord. My first prayer is to set aside and grant relief. If that is not persuasive, my lord, alternative prayer is there, my lord. Pray that your lordship may be pleased to remand the matter to the learned single bench by allowing the writ appellant to amend her writ petition or file a fresh writ petition to challenge the impugned action of the respondent counsel.
So that is what, it's okay, it's all right. It's all right. That will be enough. Just what this court want to indicate is that basically you are aggrieved by the subsequent action, the opening or operation of the clay threshi, is it?
Correct.
Now that has not been settled.
But that is the no longer surviving.
Okay, you can say that earlier tender has now it is abandoned. It is gone. No right will flow to anyone. Okay, either to you or to anyone. There will be no right. Now, if Kriyatirshi, so long they operate by themselves, there is no problem. But the moment they engage somebody, they'll have to do it by tender. And that will be a cause of action. This 2 lakhs rupees will not take away your right to challenge that. You remain in the fray.
But that is
That's
very
what,
much.
what remains, you see, it is, see, if this tender basically has abandoned, what this court can do? Nothing.
My lord, with due
See,
respect,
whether it should be situated in C. This has been done, they have made their observation, as you have seen in this, you have pointed out to this executive committee resolution,
yes.
wherein they have said that operation in such and such area may result in traffic jam and all. Now they have taken into consideration all those factors pursuant to the earlier direction of the single judge, which is not under challenge. So long this order was in your favor, you had no problem with this.
The first
Order of the,
professor.
observation of the executive committee. Okay, but the moment it came against you, but then see, whatever direction and all, it will bind all the parties. So far as we understand, sorry, just say like,
Yeah.
you see, nothing remains here to be decided. You go, even if fresh action comes, this appeal basically becomes useless for you.
With due respect, my lord,
You are
according to
seeking an amendment to challenge it. You
Second,
do it by
ordinary prayer.
fresh petition.
Alternative prayer is there. Alternative prayer is there. That is there, my lord.
So you do it by fresh petition. We will say that this thing, acceptance of 2 lakh rupees will not take away your right to challenging this thing.
But the 2 lakhs also they have transferred to my account.
You have
Since we were filing appeal, we refund it back to the council.
If you do not want that money, no problem, you don't take it.
My lord, that is the way the appellant has
We
refunded.
do not see any reason to interfere with it.
Only
Maybe situation would have been different had there been a challenge to the first order of the single judge by you.
those observations
See,
were there.
that was when this power was taken from the tender committee to the executive committee. You should have agitated that.
There is a grey area. Lordship, absolutely, I bow down. There is a grey area where
You are the
appellant would
master
have
of the
asserted.
litigation. See, if any grey area is there, that is created by you because at your instance.
Well, we would have challenged that part of the observations in the first judgment. But district council lordship may keep in mind that the executive committee has already exercised the reconsideration already.
Yes, they have access.
Reconsideration already, and therefore they found that Mukuntur is suitable. Lordship, see the letter issued by them.
This is the first one. The first was this thing. But then there is subsequent thing.
But the subsequent for recalling, they based on the legal notice.
See,
My lord, these are the subsequent actions, my
that
lord.
is why this question was that to what extent they could have reconsidered it. Okay, but whatever the case, now the situation has come to that it would result in causing traffic jam.
My lord, that is absolute.
Now, see, now you may say that so long that land was offered by the other person,
Yes,
there was no this thing.
there is not.
See, that is what district council has practically experienced. They have run it by themselves when they said they know. There is every likelihood that will cause a traffic. So that goes. And now when this creature will be this thing settled, you will take part in the tender.
My lord,
And that will be this thing. This will be strictly saying that district council cannot this thing allot it to anybody for running. So long they do not. If they want to give it to anybody, they will have to do it by tender.
my lord, with due respect, may I just reply that they use the word abandonment or done away with the tender process. My lord, it is not done. They have, my lord, after single bench judgment, they have examined it and found Mukuntur suitable
That is at that point of time.
at that point of time.
But then
And they give
after-
me
after-
and they give me
subsequently
offer.
after the single bench order.
No, my lordship can see. The single bench first petition also, when we offer, the technical committee, tender committee found my also suitable. He is also suitable, 3 of them. Therefore, qualified.
Technical
Bits. Now, therefore, when we challenge the appointment of Mr. Kindia, they come up with that subsequent development is the instruction is there from the government. Therefore, learned single bench after setting aside Mr. Kindia appointment, asks the executive committee to consider it, keep in mind these subsequent developments, the requirements, traffic and others, and you take a final decisions. Now, they have taken a final decision on that. And they
not taken a final decision.
my
This is
lord,
modified.
no, lordship, no,
That was not final decision.
no, lordship, kindly see the letter. If lordship, I draw lordship attention again to this letter only. My lord, that letter, it will reflect. My lord, page number 88. This is after a single bench direction.
I think you have taken us to that only.
My lord, I have taken, my lord, just to reappreciate the what exactly, my lord, contained therein. My lord. 88.
Yes.
My lord, may I just read? With reference to the subject and letter cited above, my lord, they have quoted the High Court order also on the top, my lord. Above, I am directed to inform you that the Executive Committee, July, in its meeting held on has relooked into the matter of Mukuntur check station, point station, for identifying, detecting the illegal trading by non-tribal commercial vehicles without license by High Court orders. After deliberation, the Executive Committee has decided that the allotment of the check station may be considered to be the highest Peterson's Ritalin if the location of the land to be used for the purpose of the check station is feasible for the check station with lay-by. Therefore, you are, my lord, therefore, you are requested to arrange a suitable land with lay-by that can be used for purpose of operation of check station so as to not to disturb the movement of traffic along national highway. Kindly note that you are comply with the requirement of providing land and lay-by for operation of check station within a period of 2 months from the date of issue of this letter for consideration of the Executive Committee. So here they mentioned the Mukuntur. That we have reconsidered.
That is not a final order. I say like they were kind of arrange a suitable land.
Yeah, arrange suitable
now,
land.
You arrange, the suitability will be again assessed. That is what.
Therefore, arbitrariness, my lord. If I give a different land, my lord,
See,
which was never.
Your argument, what we could understand, that so long that piece of land was offered by the other side, it was all right.
Yes.
But then when you yourself offered this land, that is considered not all right. See, think the thing. There were two differences. The time when it was offered by the other side, the single bench order was not there in operation. Neither district council went by himself to assess the situation. Now, whether they could have rightfully done or not, after technical bits or not, that question you cannot raise it in view of the order by the single judge, the first round of litigation. So we assume that they had the authority to go and assess, and they assessed it. Now, if that piece of land is again offered by that person also, district council cannot accept it because now it is not suitable. The suitability, according to them, is now that. So that is the only it remains. So far as your harassment, you have got 2 lakhs.
Well, that is another
the
phase
other
of
will
it.
remain open. Why do these things? That will remain open.
But
that is the best possible solution.
Whether, my lord, my argument is, my lord, making out point for lordships to consider or not. But my humble submission is that the decision taken by the Executive Committee, which is held by the learned single bench, also illegal. My lord, subsequent changing to another places, my lord, that the writ petition is not required to challenge. Suppose if we challenge the clerency, then they'll go to Karampani during the pendency. Then that will keep going on and on, my lord. Therefore, the learned single bench observation earlier, lordship pointed out, with a limited observation to the District Council Executive Committee, that keep in mind when you finalize this. Because the learned single bench very much aware, technical bits, everything is finished already. Therefore, learned single bench set aside. If my contention was not suitable, found suitable or acceptable, learned single bench earlier, first revision, could have dismissed my writ petition. But learned single bench understood that yes, technical bit, everything done. There is no obstructions other. Government District Council take a plea that there is government instruction is there. Keep in mind before you finalize it. That doesn't mean that you overrule, my lord. This High Court do not give power to the Executive Committee to overrule everything and settle a contract. But that is not permissible because the NID is there. NID was not set aside. Contract has to settle within the NIT.
What is the situation at Cleartree now? Is the check station run at Cleartree?
Earlier they have endorsed to Mr. Dang. Now they have removed him,
So what is
and now they are running. They say they are running by themselves.
okay.
District Council is running the gate.
You're running.
They are running by themselves.
By the staff of the District Council, they are running the gate.
See, once you run a station, you have the infrastructure there.
My lord, what happened, my lord? Mukindur is 5 kilometers before if you go from here, my lord. And that is a narrow road, my lord. And because of all these
Yes.
court cases and what District Council did, they leased a land, my lord, at Cleartree in the name of District Council, my lord.
So how will that affect the case of the appellant here?
Well, basically, my lord,
If the appellant succeeds, then you have to, disband the or close down the
Cleartree, my lord.
Cleartree. That becomes another
Whether
cause of
lordships
action.
will go to that extent, my lord, that is a question, my lord. In my humble submission, District Council is the best person, my lord, to take a call which place is suitable or which place is not suitable, my lord.
No, but as my
If they are
brother,
aggrieved, as a lordship pointed out, if they are aggrieved by our shifting the check gate to Cleartree, my lord, they can challenge that decision. Your lordship can examine that aspect, my lord, whether we have the authority to do that or not, my lord.
but there was a subsequent action.
So subsequent action, my lord, what happened, my lord? They challenged in the first round of litigation, my WBC 29. This honorable court granted a stay order and allowed us to run the check gate at Mukindur, my lord, departmentally. While running at Mukindur departmentally, my lord, we faced a lot of difficulty, and that was the time a decision was taken to lease out a new plot of land at a distance, my lord. But this is on the Joy bypass, my lord. The road is very wide there, my lord.
Sorry to interrupt.
My lord.
Mr. Sangreso, are you done?
My lord, if lordship permits me, I have a few authorities to rely on to support my arguments.
What you can do, like usually I do, I know my brother may say otherwise. If you can just list out just points of your argument in written synopsis along with your authority, that will be helpful.
But that I
We will continue with your argument on next date.
My lord.
You have to say it. So you do that.
well, Mr. Lordship will resume the hearing in another day. Lordship, then
Yes, next week. Because we have to, sorry, we also have single.
My lord,
And I believe at 2 o'clock we have a condolence. Have you heard about it?
Today, my lord.
Today, I think. Notice has been issued, or
We have not come there.
just for the information of the, I think you all are aware or you knew about the news.
yes, we
One
are
of our
very sad.
judicial officers has passed away.
My lord.
So, we intend to have the condolence meeting.
My lord.
We will inform the members.
So all the councils here are invited, rather are requested to be present. You may have received notice or not, but please.
Good. Well,
So after one,
this matter, my lord, when shall we, my lord? Shall we complete tomorrow or subject lordship convening? Hearing
would you?
to complete the arguments tomorrow and submit the submission of those citations from my side, my friends.
You have not yet completed the argument.
My lord, I will conclude a few points we will highlight, my with lordship permission.
So tomorrow,
Tomorrow, my lord.
or Mr. Sangreso, Senior Counsel for the appellant. The hearing will continue tomorrow. List the matter accordingly.
Obliged.
My Lord, I beg to seek an indulgence of my Lordship to move unlisted motion tomorrow. Urgency is involved, my Lord. Headmen, the 5 headmen were elected last 2022 for a period of 5 years. Now it is renewable every year. Renewal, they used to renew. Same ship used to renew. In the last month, my Lord, in the month of August, there was a complaint that the petitioner here is functioning the village without the collective opinion of the other Shanong members. There was a complaint raised by the chief. The chief heard the matter, and the chief said that since your election, the 1-year appointment is over, you cannot continue. Matter went to district council court, and district council political appeal, and executive committee has passed the order that since your appointment is over, there should be a fresh election. Whereas to the remaining 4 of them, recommendation were there and extended. And now chief has fixed today to the election to be held day after tomorrow, madam. So if Lordship allow me to move it tomorrow.
But that is a perfectly logical decision.
No, my Lord.
If the rule or law provides for re-election, and if re-election is called, you are entitled to contest.
But my grievance is my election is for 5 years. All of us were elected for 5 years. But only the appointment letter, it mentions 1 year. And they used to renew every year.
Okay.
And for 4 of them, they have renewed. Okay. But to me, excluded.
So it would be renewed from year to year?
Year to year basis.
The 5 years period is over?
Yes.
Then re-election?
Then re-election comes. So 4 were extended. I was removed. And now chief fixed today, issued an order, the election to be held day after tomorrow. So if Lordship allow me to move tomorrow.
Okay.
Highly obliged.
Yes.
Please, Your Lordship, I beg to mention item number 12. Will come after 2 weeks.
What is 12?
Item number 12.
Item number 12.
Contentment matter, Lordship.
This is with regard to that notification?
No, Lordship. This is relating to inclusion of the name of the petitioner in the mutation and all. Lease agreement.
On pre-made by the petitioner? This is matter after 2 weeks.
Similar prayer for item number 6. Since the conducting council is having some personal difficulty.
Your Honor, this case is tracking from 2020 for small, only for small issues.
What is the case about?
This is about non-implementation, non-adherent with the rules of the SPV, Lafarge, fund from Lafarge. So that's our grievances. So, but
so Lafarge is a party here?
No, it's not. But SPV. Implementation of the funds.
But that is being done by the Lafarge, isn't it? On the direction of the Supreme Court.
Yes. That is good. In Lafarge Yumiam Private Limited in 2012, 2011. This.
Anyway, we'll see. What is there?
That'll come after 2 weeks.
On pre-made by the respondent. Not objected to by petitioner. This is matter 2 weeks. Let's see, if there's a small matter, we'll finish it off.
Right.
I'd like to mention item number 5. I was supposed to get some instruction to file one document. I could not. I pray for 3 weeks time, my lord.
Only with regard to that.
Yes, that sawmill.
Yes. Notification.
Notification. One document was there. So
just to ascertain whether those high tension wire were were set up before the permission was given or something of the sort.
This particular document which my senior is referring to was based on the submission made by we said that there were some objection raised, and they said that we have also made some mistakes. Now the petitioner says that we have actually unauthorisedly constructed, to which we said that there was already a letter issued by the Commerce Department said that that order has been, my lord, it was revoked. So I brought this into the lordship as directed the state respondent to take instruction on that letter, my lord, which I have given, because that letter was given to the petitioner by the Commerce Department, my lord. So that letter is yet to be still filed, my lord, to bring on record.
It's the same.
So 3 weeks, my lord.
What do we do?
Because they've been because the last occasion was saying that this is the last things, but
I got that. But no, next week, next year.
We are lingering. You see, we are lingering here.
this matter. Because if lordship, if they bring the documents, so I have to file again rejoinders on that on the basis. So it will happen. So as soon as possible, is the matters can be taken up because this matter is right from the pending for 2018.
I'll try my best.
You do it in 1 week's time.
My lord, it's difficult. Till date, I could not contact. I'm trying to get the correct address. I'll do it within 2 weeks, my lord.
But Mr. Barwa said this is the.
Then we can go for hearing without the documents.
Court has.
If
court has
the
observed
document
that
is
this
not denied by him, if it is
No,
admitted, then we can go for
we are not
hearing.
saying that because they have to bring the things.
No, if
I don't know what is the document
that
about.
means he is disputing the existence
I am
of the
not disputing
documents.
it, lordship. We never uttered the such thing because if they bring, then I have to find the rejoinder. I don't even know
If
what is
they
the
admit,
document.
then we can proceed with the hearing. Our pleadings are already completed.
Do it within.
2 weeks, my lord.
Let them bring. If say is to be
But
filed.
if you do that, you see.
No, a letter was addressed
As
to
I
him.
as I used to, request the parties, file it, advance copy to the
Yes.
to the
The
petitioner,
moment I get.
and if rejoinder is to be filed, you do it simultaneously.
Just to bring on record.
Mr. Leonard, additional senior GA, Mr. S.N. Gupta has submitted that the document which is sought to be brought before this court by way of an affidavit could not be done so today in spite of the best effort of the Leonard Council, and as such has prayed for last chance for the same to be filed before this court.
Might not
Give you a
be
last
the
chance.
last chance, my lord. The word last chance is
Because
very.
that is why I say, if you cannot do it, then we'll continue with the.
Otherwise, we'll proceed with the hearing.
Otherwise, that is why if you don't.
I'll make an attempt to complete it.
Please.
Yeah, your lordship, if they cannot in the next occasion, then we can continue the
Exactly.
hearing.
That's what I said.
Because it's partly hard. So now only one issue.
Obliged, man.
Want to go? Leonard Council for the petitioner has no objection to the preamble, but has, however, indicated that he may be allowed to file a rejoinder if so advised. Accordingly, parties are to file the said affidavit and the rejoinder within the next date fix. As prayed for, this is not up to 2 weeks. Almighty last chance.
Obliged.
I'll cut that last chance, but let it be a last chance.
Obliged.
May I please, Your Lordship, I beg to mention contempt case number 29 of 2020. Actually, this matter was supposed to be listed in Sir Justice Thank You Court, Your Honor,
so?
Your Lordship, but then, sorry, Honor.
What happened? Why you want to mention?
Let the matter be listed on 30th, Your
Why?
Lordship.
What's the hurry?
Because there is urgency.
30th, he'll be there in court.
Yes, Your Lordship, but then it's not listed on that day.
Then you make a mention before it's court. I think by 30th, court will be functioning. If the matter is,
All right, Your Lordship.
seasoned by the court, do that.
All right. Obliged, Your Lordship.
Wait, please, Your Lordship, I beg to mention item number 11. If this matter may be taken up after 2 weeks, Your Lordship.
My lord, may the matter come after 3 weeks, my lord. Because in the meantime, we expect that even the evidence, the pending case will also, it's also smoothly going on, my lord. So
What is this a writ
suspension,
petition?
my lord.
Suspension of the writ petition,
And
Your
the
Lordship.
POXO case is pending against the petition, and it's going on, my lord.
Your Lordship.
And we have been informed that it is at the stage of evidence. So, my lord, I believe there will be some, if at all required, my lord. So this matter can come after 2-3 weeks.
As far as the criminal proceedings are
My lord.
concerned, we don't know how long it will take.
My lord.
Your Lordship.
And why have you come here?
Your Lordship, this is with regard to the suspension of the writ petitioner.
What is your grievance?
Your Lordship, setting aside this suspension.
The challenge is suspension order, my
But
lord.
you see, if you are involved in a criminal proceeding, I believe the rules provide that you are to be suspended
Your Lordship.
Yes.
pending inquiry.
Yes, Your Lordship.
So how long you want?
3 weeks, Your Lordship.
3 weeks. Go to next. One, two, three. On plea made by the petitioner, this is matter of the 3 weeks.
Much obliged. May I please, Your Lordship? Your Lordship, I beg to mention item number 14 on behalf of respondent number 2.
14.
Your Lordship. For the petitioner, Your Lordship.
Any objection?
No, Your Lordship.
On plea made by respondent number 2. Not objected to by petitioner. This is matter of the 2 weeks.
Much obliged, Your Lordship.
May it please Your Lordship, I beg to mention item number 8, Your Lordship.
Number 8.
Number 8, Your Lordship. Your Lordship, here we were supposed to file a response to the rejoinder affidavit, Your Lordship. I pray if this matter may come up after 3 weeks, Lordship.
What is this matter about?
This matter is pertaining to financial upgradation under ACP and MACP, Your Lordship.
Petitioner is an employee of which department?
Assam Rifle, Your Lordship.
No objection.
On prevision by the respondent, Union of India, the same not being objected to by the petitioner, matter is now posted after 3 weeks.
Similar prayer for item number 9 as well, Your Lordship, as they are connected matter, Your Lordship.
You are also here.
Yes, Your Lordship.
They are connected.
They are connected, Your Lordship, but then in item number 9, the pleadings are completed, Your Lordship. Except in item number 8, Your Lordship, we would like to file a response to the rejoinder affidavit, Your Lordship.
Same order.
Much obliged, Your Lordship.
May it please Your Lordship. Lordship, I beg to make a mention of item number 13, Your Lordship. Lordship, the senior conducting counsel needs some more time in order to prepare this matter, Your Lordship.
You are for?
Dr. N. Mosika, Your
No,
Lordship.
you are for
Yes, Your Lordship.
petitioner.
Yes, Your Lordship, a petitioner.
I'm for respondent number 2, Lordship.
And who's for us? You are for?
I'm appearing for respondent number 1.
I pray if this matter may be listed after 2 weeks, Your Lordship.
Any objection?
No objection. No objection.
Any objection?
No objection. No.
On plea made by the petitioner, this is matter up to 2 weeks.
Obliged, Your Lordship.
Daily causeless, item number 1.
Mate, this is Your Lordship. Lordship, in fact, this matter has become infructuous, Your Lordship.
Why?
Lordship, Lordship will kindly come to page.
No, see, look at the last order.
They are aggrieved by the, if
No,
Lordship.
Mr. Shulai, the last order of this court. I think No, what's the last order? Last order was since May.
Because of the division bench matter, Your Lordship. They have been dragging, Your Lordship.
Oh, list this matter. So what is what's the matter before the division bench?
Lordship,
disposal?
the government now is proceeding, Your Lordship. Government has also agreed in
Well, it has not yet been disposed of.
No, Your Lordship, still pending. If Lordship can in this matter, Lordship can come to page 107.
But the petitioner is not here, Mr.
Lordship, because of that writ appeal, Your Lordship, that's why they are not here. Lordship may kindly dismiss it for default, Your Lordship.
That cannot be. We'll have to give them a chance. This order, last order was passed since May. They may not be aware of it.
Lordship, because of the writ appeal, Your
And
Lordship.
the order specifically says list this matter on 28th. So today.
Lordship, they are not here.
Well, we'll look at it next.
Well, let it come after vacation, Your Lordship. After vacation.
None appears for the petitioner on prayer made by Mr. Indishwa and our AAG. The matter is now listed after vacation.
After vacation.
Item number 2.
In this case, I need some time to file my affidavit.
Your Lordship,
Yes.
well, the question here is whether they have complied or not. My instruction is that they have not been complied. There's no compliance with the orders passed by this court now. It's over 9 to 10 months.
Your Lordship, I need some time to file my affidavit. Your Lordship.
Affidavit is only to this extent that whether compliance has been done or not, or else.
So, given the position, what's the position? What we have taken the action?
1 week, Your Lordship.
1 week. Mr. R. Definite Leonard CGC has submitted that the instruction sought for could not be has not yet been received, and has accordingly sought for time to file the affidavit on receipt of the same. On premium, the same is allowed. This is matter to 1 week.
Right.
Yeah, what Mr. Nombri said is correct. You just have to just.
There's no question of going back to the merits or not.
Yeah, whether it has been complied or not.
No, Your Lordship, we are not going for the merit of the case.
The essence of a contempt matter is whether it has been complied or not. If there's willful non-compliance, then you are liable.
At least they can say that give us another 2 months time for compliance.
You could just that you could have done.
No, Your Lordship, in the matter that's already has taken up the matter with the ministry. This much information is there. Already is taken up the ministry, because as soon as straightway they cannot. So they have an inter-ministerial and other.
That is why you get instructions along those lines.
Yes.
Once you give a definite
timeline.
Answer that this matter will be looked into, and the order will be complied with within, as Mr. Nogri said, within such and such a period, then that matter ends. Otherwise, what happens is, contempt matter. Finally, somebody has to appear in person.
Absolutely, Lordship. Obliged.
Item number 4.
Please, Lordship. Lordship, in this matter, Lordship, I was required to obtain the instruction. Lordship, the deputing of the expert member in the interview board practice. Whenever the MPSC requests for an expert member, a senior lecturer is deputed in the interview board.
Mr. Karmi, I think what the court would require is for you to bring on record certain precedents, file notings, or instructions, or
yes,
whatever.
yes, Lordship. I'll file the affidavit.
That is what is required, so that this court will know whether you say precedent. Yes, it could be. How it is done. Otherwise, it cannot.
No, I'll file the affidavit.
Cannot be
right
done
now.
on on the air.
Yes, I'll file the affidavit, Lordship. Right now, I'm just apprising the court.
Some procedures are there.
Exactly.
It is by convention. I have received the instruction and I'll file the affidavit.
But
I'll bring on record.
Again, there must be something in writing. Some noting must be there. File noting. Some precedent followed. How was the convention started? All those things has to be
In this
there.
matter, Lordship, the deputation order is there.
So
Connected with this instant case. I'll bring that on record.
So 1 week.
Lordship, yes. 1 week.
Mr. H. Harmi Leonard, additional senior GA, appearing for the respondent 1 and 2, has submitted that the instructions sought for could not be received and has paid for some time for the same for the relevant information to be filed by way of affidavit. it is prayed that this matter may be posted after a week. On premium, the same is allowed, list accordingly. What week?
Item number 7.
Obliged, Lordship.
May please, my lord. My lord, with your lordship's permission, I'd like to withdraw the instant matter, my lord.
Withdraw?
Yes, my lordship.
Why?
Well, we have received instructions from our client that no longer interested to pursue the matter. So, as such, I may be allowed to withdraw the instant matter with the liberty if arises.
Second appeal.
Second appeal, my lord.
Issues of law to be decided.
Exactly.
Mr. CCT Sama, Legal Counsel for the petitioner, for the appellant, has submitted that he will be allowed to withdraw this petition. On premium, this will be allowed this appeal. No? On premium, this appeal is accordingly dismissed as withdrawn. Dispose of accordingly.
With the liberty if any, my lord.
Oh, that is up to you.
Much obliged.
Deeply obliged.
Item number 10.
Please, Lordship, in this matter, actually we have withdrawn as a counsel for the petitioner, Lordship. So, Lordship, I have to take instruction whether they have accepted our request or not, Lordship. So, I have to take instruction.
The Mr. Legal Counsel for the Legal Counsel has submitted that the conducting counsel, as far as the petition is concerned, has withdrawn from this proceedings, and as such the petitioner may be and as such the petitioner has been informed of the same. You have informed the petitioner?
Lordship.
This being the case, the petitioner is directed to make arrangement for appointment of a counsel to take up this matter. Mr. Thaba is also here.
This is Thaba, Lordship, yes.
So Mr. Thaba has withdrawn.
Withdrawn, Lordship.
And Mr. Paul?
That do we have to take instruction.
No, who's who? Because is Mr. Paul and Mrs. Thaba in the...
No, we are together, Lordship.
They are together?
Lordship, yes.
All of them have withdrawn?
Yes, Lordship.
Now you say I have to take... Now you say...
No, Lordship, actually we have sent a notice to them whether they have accepted or...
That's right.
actually.
So it's not yet final?
Lordship.
That's
why we have to take instruction, Lordship.
Mr. Legal Counsel for the petitioner has submitted that the counsels for the petitioner has given their intention to withdraw from this case as counsels, for which the petitioner has been intimated. However, till date, there is no response received from the petitioner, such is spirit that this matter may be as far as the same may be awaited. Next. On consideration of the submission bid, given the fact that the council have given their intention to withdraw from appearing in this case, the petitioner is directed to ensure due representation by appointment of a counsel in this regard. On payment, this is not up to.
No, this matter will come up in interpretation. In case that the petitioner wishes to proceed with the case or engage in counsel, along with the in the meantime they can also do it. Yes, it will come up in interpretation.
This is matter up to interpretation. But we informed the
Yes, Lordship.
informed them. Yeah. They should also be given the opportunity
Yes,
to engage a fresh counsel.
Totally obliged.